If it pleases the court, Your Honour, my name is Brown, initials LJ, and I'll be appearing on behalf of my client, Johnny Wishbone, in this matter. Your Honour, my submissions to you today are quite simple. They are, in essence, the police had certain responsibilities under the Police Powers and Responsibilities Act with respect to questioning my juvenile client, Johnny Wishbone. This has not been complied with, the relevant section, which I will refer to later, and as such, the record of interview that has been obtained through the questioning should be rendered inadmissible as a result, where my client has actually basically made full admissions to all 106 charges against him. Your Honour, before I jump into the substance of my submissions today, I wish to bring to your attention a very, very important section, namely Section 5E of the Police Powers and Responsibilities Act, and that reads that the purpose of this Act, in part, is to ensure the fairness of, and I would like to emphasise that word, fairness, the fairness of persons against whom the police officers are exercising their powers over under this Act. Your Honour, that is a very, very, very important and particularly relevant section to my submissions today, and it provides context and the foundations to what I will refer to in right now. Your Honour, under Section 421, it will be relevant where the police wish to question a relevant person, my client, Johnny Wishbone, and where the police officer is able to form a reasonable suspicion that my client is a juvenile. Now, Your Honour, it is quite clear that my client is a juvenile. It would be clear to the reasonable person that this would be the case. Your Honour, as such, I submit that when questioning my client, a juvenile, the police should have discharged a very, very clear duty that was set out in 421. Under Section 421, subsection 2, the officer must not question a child unless contact has been made with a support person of their choice, and that support person and the child have had a chance to have a chat in circumstances where the conversation cannot be overheard. Your Honour, there has been a social worker that has been supplied to Johnny by the police. They have been put in a situation where they have been able to have had a conversation in circumstances where it can't be overheard. That is true, Your Honour. However, the support person must be a person of Johnny's choosing. The words are very, very clear, Your Honour. I have asked my client whether he knew this person. Johnny has said to me that he had no idea who this person was. He'd never been acquainted with her. He did not know what her job was. He did not know what she came there to do. Her only advice given to Johnny is to tell the truth. Fair enough. That's fair enough. That's fair enough advice. But also to answer any question asked to Johnny by the police officer. Now, I think this is a very, very especially relevant time to bring up the fact that nothing in the facts that were provided to me, Your Honour, suggests that the police had cautioned my client as to his right to silence under the Police Powers and Responsibility regulations. Nothing of this nature was relayed to my client. So when you have that, my failure to caution, and the fact that a person who is an alien to my client, telling my client to answer all questions, when you have those two facts together, we have a problem, a grave injustice, in fact. My client, being only a juvenile, would not have known that he had a right to silence, and therefore the admissions made in the record of interview may not have actually been made if the support person had actually been as prescribed by the Act, being someone that Johnny himself has actually chosen. Your Honour, there has been a gross disregard for this obligation, and therefore there has been a contravention. Further to this, also, as I pointed out, there's been no cautioning of Johnny's rights. Your Honour, the admission that he made was an example of gratuitous concurrence and should be completely rendered as inadmissible due to the misapplication or the incompetence of the police to follow very, very simple regulation. Your Honour, you have a discretion under, as stipulated in Bunnings and Cross and the Crown and Ireland, to render any evidence obtained unlawfully or unfairly as inadmissible. Your Honour, I would encourage Your Honours to exercise such a discretion in this case and render the record of admission, the record of interview, as inadmissible. Your Honours, that forms the basis of my submissions today. Thank you very much.